Thanks for taking the time today. I appreciate it. Chairman Swearingen, as well as members of the committee. Thank you for the opportunity to testify in support of AB 248 relating to vacancies in appointive state offices. I'm here to speak in plain terms about a simple fix to a problem most Wisconsinites would assume was already settled. When your appointed term ends, your time in office ends. Currently, Wisconsin law does not consider the end of an appointed term a vacancy. This has been true for decades and continued when the Supreme Court ruled in Call v. Prenn that unless statute explicitly states otherwise, appointees can remain in office past their term expiration until a successor is confirmed. This bill closes that gap by amending statute to make it clear when a fixed term for an appointive state office ends, a vacancy is created. No loopholes, no holdovers. This isn't about targeting any one person or party. Both sides have seen appointees linger past their terms when confirmation stalls. The average Wisconsinite, however, expects fairness. Serve your term, then make room for the next appointee or earn reappointment. This bill simply delivers that common sense standard. Let me address a few practical questions that have come up along the way. Who does this affect? Well, the governor appoints members to 186 boards and commissions, plus cabinet secretaries and certain agency administrators. AB 248 applies to all of them when their fixed term expires. Based on discussions with the drafting attorney, it is my understanding that this does not affect any current holdover appointments. This also intentionally excludes appointments within local governments. What if the Senate and governor are deadlocked? Current law, unchanged by this bill, lets the governor make provisional appointments. Those appointees can immediately exercise full powers of the office until the Senate acts. Can boards still function with a vacancy? Yes. State law sets quorum at a majority of authorized positions, not filled ones. But the governor can make provisional appointments, and those individuals can serve immediately. Would a deputy director run the department if there was a vacancy? This bill covers department secretaries. Deputies have stepped in briefly in the past, but provisional appointments are the normal path and remain available. Could other agencies, such as the Office of Commissioner of Insurance, grind to a halt? No. Most functions continue. Only duties requiring the commissioner's personal action pause until a provisional or permanent appointee is in place. So the bottom line, AB 248 restores the plain meaning of, quote, fixed term. It prevents indefinite holdovers, keeps government accountable, and works the same no matter who sits in the governor's office or controls the Senate. I ask for your support and welcome any questions that you may have.